Good evening, Crime Talk aficionados. My name is Scott Reich. This is Crime Talk. Thanks for joining us. This is our Tuesday night live show, affectionately referred to as After Dark, and I know it's not After Dark, but when we came up with the name, it was dark, but daylight savings kicked in. So here we are, and what can we say? Anything going on this week? I mean, it's only Tuesday, right? We've had a sheriff deputy allegedly try to help someone who's serving a 35-year sentence, or 100-something year sentence, I think it was, 75-year sentence, who's on trial for murder, but he had pled not guilty by reason of insanity. So you got that. The prosecution has given notice that Lori Vallow is that they're seeking the death penalty as it relates to Lori Vallow. They had previously already done that for Chad Daybell. Friday of last week, the court ruled, we're going to Ada County, Boise, up there for the trial. And once again, the prosecution in the Lori Vallow, Chad Daybell matter said, "Judge, put the trials together. We just can't do it. We just can't do it." And my position is prosecution should just be willing to go do this case. Okay? Tell me when, tell me where. We'll have our witnesses. We'll be ready to go. They've had 2.5 years to prepare for this at this point. They should be ready to go. Okay? I mean, trial prep. What evidence do we need? What are the elements that I need to prove? What witnesses do I need to prove each and every element of the charge? Keeping it as simple as possible. You write it out. I need this witness. I need this piece of evidence that I'm going to get in through this witness. Oh, I better bring this witness in to lay the appropriate foundation. They've had 2.5 years, for goodness sakes. Like, they should be ready. They should literally be saying, "Judge, other than scheduling, need a little notice to get my witnesses here. We'll be ready to go." Okay? I just don't understand why they're so, what's the word I'm looking for? They're so stressed out about having to do this case twice. What's the big deal? I've known cases where the prosecutors tried the case 2-3 times because each of the co-defendants has made statements against each other. So there's severance issues, and the DAs just go do it. I mean, get it. Nobody likes to do it, but that's your job. So I don't have a whole lot of sympathy for the prosecution when it comes to that. Just go do your job. Go try it, okay? We can also talk about, but we're not going to talk about anything other than the Depp case except procedurally what has taken place today, okay? We're not going to get into who's the worst person, okay? We're not doing that. Or who's the best person in the world. We're definitely not going to do that. So yeah, that's what we're going to do, because we're not going to do that. And then, excuse me, sorry. Don't know why I just had to choke there a second. And then, of course, we have the Supreme Court leak today that is kind of making a big brouhaha regarding, obviously, the potential fact that Roe v. Wade would be overturned, at least if the vote count at the Supreme Court stays the way it is. And like I said, we're not going to get into the issue. We're only going to talk about the legal issues. We're not going to get into whether it's right or wrong or morally or legally, okay? And, I mean, there's been issues. I remember going to law school and the constitutional law professor saying he totally agreed with the Roe v. Wade decision, but he said if you're going to be intellectually honest, it's one of the worst written opinions ever to come from the Supreme Court. They made it up, is what he said. This is my law professor. They literally made it up, which is what some people say is judicial activism, where the judges want a result, and then they work to it and do legal gymnastics to get there. So that's where that's what I remember hearing about, in law school. So it's not some new argument. It just goes to how people think that the Constitution should be interpreted. Let's see here, Jody. Jody wants to know, Scott, can you please explain why the whole Roe v. Wade got brought back into the limelight? I mean, for 50 years, that's been the law of the land, and then all of a sudden states are taking away a woman's rights. Well, good question. How did it all come about? Well, and trying to lay out all the facts that we know. So Roe v. Wade becomes the law of the land. The court says that within the penumbra of the Fourth Amendment, various privacy rights, it must include the right to have an abortion. And that's what is a gist the Supreme Court said. Like I said, we talked about in the video today, just looking at it as a strict constructionist would look at it. Obviously, nowhere does the word abortion appear in the Constitution, and therefore, how can you say there's a right when it's not specifically enumerated, right? Statutory construction. If the drafters of the Constitution or the drafters of a statute wanted to include something, they should have put it in there. By explicitly not putting it in, it's basically saying it doesn't exist. That's the other side of it, of the argument. And I'm not saying which is right or wrong. I'm just saying this is what it is. Okay. So over those time period, states have been putting restrictions on various timelines as it relates to women who wanted to receive an abortion. And there's the Casey case that was kind of it was Planned Parenthood v. Casey, 1992. And that was kind of the last real challenge to Roe v. Wade. And in that particular case, let me just pull this up here, make sure I get the language correct because I don't want to get it wrong. It was a case regarding abortion. It's a plurality decision, which means it's 5-4. The court upheld a right to have an abortion that was established in Roe v. Wade and altered the standard for analyzing restrictions on that right and whether there's crafting the undue burden standard for abortion restrictions. So once again, the Supreme Court comes up with a law, or they come up with a legal standard in Roe v. Wade. And then over the years, I mean, that was, I think, 73, 1992, almost 20 years later, here they are saying, hey, but what are all these restrictions? You can't put any undue restrictions on a woman's right to obtain an abortion. And over the years and ever since then, there's been more and more restrictions. The case that made it to the Supreme Court is the Mississippi case. And basically what it says is that the legislature put restrictions on it, on when abortions could be performed. I think in that one it was 15 weeks, I believe, is what the law states. And so what that does is it went up to the Supreme Court. A clinic, a clinic there. Let me pull up the name. I want to make sure I get it right. Sorry. I had all this stuff printed out, but we threw it all away.
Oh, was it in that pile?
I think so. It's all okay. It's all good. Yeah, it's all good. The Dobbs v. Jackson's Women Health Organization. And like I said, yeah, they limited abortions to any time within the first 15 weeks. and the way it was probably going to be upheld. And if you believe what was being reported in the news today, and the fact that Chief Justice John Roberts isn't in the majority, is probably in the minority, is that he would keep Roe v. Wade, but probably allow the 15-week restriction. And so that's going to obviously create issues if it's another plurality decision. And like I said, so the legislature then in Mississippi holds hearings, right? Because you can't just create a law unless there's some reason to do it. So they hold a hearing and they bring people in, and their analysis was, as I understand it, that the science has changed from back in the early 70s, from Roe v. Wade era, that basically they say after 15 weeks, the little embryo, not embryo, but the baby inside the womb at that point can actually feel pain. And so they're saying, hey, we're going to protect the little child at 15 weeks, and therefore you cannot subject them to this type of pain. And that was where it went. And so this reproductive clinic in Mississippi sued, saying, oh my gosh, you can't put this law into effect. Obviously goes to court. There's litigation. It's, said, hey, that's an undue burden. You can't restrict it, right? Relying on Casey. Goes up to the appellate courts, all the way to Supreme Court. Supreme Court looks at it and says, this is our chance to reverse Roe v. Wade. And obviously, I talked about it today in our video, and like I said, we're not taking sides. Here's the argument. You decide, okay? It's a lot of people are saying you can't overturn precedent. You can't overturn precedent. This is just wrong. You can't do it. It's never done. Well, Supreme Court reverses themselves quite a bit. They change their mind, and sometimes throughout history, it's been good that they've changed it, right? Brown versus Board of Education, separate but equal. Remember all that stuff? If they said, well, it's Supreme Court precedent, separate but equal is good to go. I think most people think that's not fair. That's not right. That's a violation of people's constitutional rights. So the Supreme Court reversed themselves. There's been some major cases out there where the Supreme Court has changed their mind, reversed themselves. So it's not completely unprecedented. And like I said, not to get into it, but like a political argument, because I'm seriously not trying to go. We're going to stay strictly on the legal issue. But this is the issue that courts have. What is the role of the court? Is the court there to follow the law, right? This is what the legislature said. This is what Congress said in the statute. If the statute is inartfully or poorly written and it didn't convey everything that the legislature wanted, well, most on the judiciary would say that is not the role of the court to fix it. The role of the court is to say, this is the way I have to rule because this is the plain language of the statute. Yes, I need to give all the words that are plain meaning and effect at the time of their drafting, but they can't remove what doesn't exist, and they can't add what doesn't exist, okay? That's what people get into, what they refer to as judicial activism. Judges like, well, it's a sad, sad situation, and although the law says I have to do a certain thing, I don't want to do it, okay? Think about all the times where you've heard of a case where somebody is going to be sentenced because there is a mandatory minimum sentence. The legislature's drafted it. They've held their hearings. They're representing the will of the people, and they say, we believe this crime carries a punishment of no less than 30 years to life in prison. And we define life as at least 70 years or something, right? The judge goes to court and is like, wow, this is a really bad situation. Clearly something bad has taken place, but maybe the person is so young and such a good future. It was a complete aberration. And oh my gosh, this is such a terrible thing. So I'm just going to ignore the law. Well, you would say, Judge, you can't do that, right? The prosecutor would say, Judge, you can't do that. That law was there to protect the public. It's there to protect the victims of the crime and make sure there's punishment for the crime. And that's what the legislature says. You may not like it, but guess what? There is a remedy. It's called the legislature. It's called going to Congress and changing the law. And that's why, we talk about these laws, okay? The legislature, the Congress are the ones that write them, okay? And oftentimes they come up with knee-jerk reactions to laws because it's the flavor of the month and they've got to do something to show their constituents that they're out there doing something really good, okay? And I'll be honest with you, I make a pretty good living, obviously, when people mess up, but also because the legislature writes terrible laws. And I don't mean in the sense that they write terrible laws like it's a bad intent. No, it's just bad law writing. They don't reference it. And why? Because they don't actually usually draft it themselves. Some lobbyist will come in and say, we need to change this. I mean, you could be the district attorney's council. It could be the criminal defense bar, the trial lawyers. It could be a lobbyist for, you name it, big tech, unions, whatever. And they say, we need to pass this law. Will you sponsor it for us? And they read it, look, wow, this sounds good. And besides, after all, you donated all that money to me anyway. So yeah, we're pro whatever, right? So they go through, they have a hearing, they get it sent to a committee, they introduce the bill, it goes to committee, it gets assigned to committee, they go to a committee, they hold a hearing or two, they pass it, they vote on it, it goes to the full house, then it goes to the other house for consideration. Next thing you know, it's the law. And in reality, nobody ever read the damn thing, right? Maybe some staffer along the way that maybe made some notes, highlights, this is bad. This didn't really go along with the other statutes. We forgot to add this section, and it never gets done. It never gets done. And so the laws are poorly written. Then it's up to the court to try to interpret the law, right? That's the rule. I mean, the executive branch is to enforce the law, all the laws on the books, not just the ones they pick and choose and like. They're supposed to enforce them all. The legislature is to draft the laws, and the courts are to interpret the laws. Little civic lesson right there. Interpret. And so, as some people will say, oh my goodness, the Supreme Court acts as a super legislature accountable to no one if they just, at a whim, say this is the law. Okay? And what does this really do? I mean, if this is opinion, the Dobbs v. Mississippi, was it Mississippi versus, why I can't remember the name of this thing. God, it's just, Dobbs versus Jackson Women's Health Organization. Let's say all this public fury comes about, and the vote is 5-4. Maybe Roberts comes on at 6-3. Okay. Then what happens? Well, basically it says the states have the right to pass laws putting restrictions on abortions. And they can say no abortions. They can say you shouldn't be able to have one until 15 weeks, 25 weeks, maybe only in cases of rape, incest, or medical issues related to the mother, something along those lines. And that's what it means. So, like I said, there's no law, at least I'm aware of, on the books that says everybody has a right to an abortion. It's I'm not aware of any that you can go and say, I want to pull the United States Code and look it up. It's the Supreme Court in Roe v. Wade said, this is the law. So what does it do? It just means it would all go back to the states, and each individual state would have to come up with the laws. Like we live in Colorado, for example. As if I recall my history correctly, Colorado was one of the first states to make abortions legal, I think, in 1969. And some states, depending on where people live, would say we should have no restrictions. Other people say we should have absolute restrictions on everything. But it's kind of a local issue. I mean, think about it. When you travel, and if you go to states, I've been in Texas where literally I've gone to dinner with people and they're like, well, we got to go one more county over because that's a dry county. You're like, what? Like, yeah, it's a dry county. The residents have decided they don't want liquor served in their county. Seen that in Utah as well. But you say, but it's legal everywhere else. So this jurisdiction has said this is what they want. It's kind of a local thing, right? So the states will have to decide what they want based upon the will of the people. What can you say? I mean, there's certain things you can do in some states you can't do in others, right? Think about when they, I guess, legalized marijuana. You could buy it here, but you couldn't transport it across state lines. You couldn't take it anywhere else because it would be illegal. You're back to that. So, I mean, there's certain things. I mean, if you really get into the nitty gritty, the old Constitution here, that's right, the little pocket Constitution. When you read it, it's not that long, and it doesn't. I mean, the original intent was that it not to be, when this country was founded, that the federal government not to be that powerful, that the power was reserved to the states, right? People didn't like the king. If it's coming from, say, Washington, D.C., they think it's kind of like, well, the king. So let it be written. So let it be done, right? And that's it. People want individual control at the lowest level possible. So that's where that stands. So, Jody, I hope that explains what it is. Basically, the Supreme Court giveth, the Supreme Court taketh away. And then the other issue is if you think about it, one of the other issues that was kind of a states' rights issue, and it could breathe some life back into the dormant 10th Amendment, the whole 10th Amendment, anything not specifically enumerated. Let's just get the language right. The power is not delegated to the United States, right? Very limited. The only thing delegated to the United States. So the power is not delegated to the United States by the Constitution, nor prohibited it to the states, are reserved to the states, respectively, or to the people. Think about that. Which is the fundamental principle of our, constitutional republic. That's right. We're a constitutional republic. We're not a democracy. Just remember that. Another civic lesson here. It's a constitutional republic. And that the power comes from the people. And the federal government only has the power that the people have delegated to it. And if you look at it, it's very, very limited. Interstate commerce. Obviously for, power to have war and do trade and things of that nature. Immigration, those are the things delegated to the feds. But way off base. But you could go back to FDR and his court packing scheme, right? Because the courts kept striking down his New Deal. And he was like, well, if you're not going to give me what I want, then we're going to stack the court, right? Have we heard that? Yep. You don't give us what we want, we're going to stack the court. I mean, there's nothing that says there has to be 9 justices on the Supreme Court. Congress can change the number at any time they want. My humble opinion is you start having, you become a little banana republic, depending on who's in charge, who's in power, that the Supreme Court starts stacking up. You just want people that are going to be intellectually honest. All right, have a super chat here. And as you've noticed, we don't ask for super chats. They're appreciated because they make them stand out. Scott, do you support law schools migrating to 2 years instead of 3? Good question, Leslie. Now, it's been a long time since I've been to law school, okay? And you have to remember, the first year of law school is when you get all your kind of core classes. You get contracts, you get torts, you get civil procedure, maybe like a crim law course. You get kind of the fun contracts, kind of the core stuff you need, right? And first year is pretty intense, but it's not anything you can't do. You just have to, it's a lot of work, okay? And when I went to law school, I mean, laptops were kind of coming into like being a thing. People would take notes. I'm still a paper guy. I like paper, but I get it. You know, I just like paper. Anyway, back then, you know, now everything's so easy and it's accessible. I mean, you know, yes, law school is probably 3 years. Actually, how do I say it? Law school is actually a 1-year course, 1 year spread over 3 years. That was very inarticulate the way I said that. Law school should be 1 year, but it's spread over 3 as of right now. And why do I say that? I think it should go the route of like medical school. Okay? The first year medical students, right? It's all books, it's cramming, teach you what you know, boom, boom, boom. And then they go out and they go do all their stuff, their rotations or whatever it is, and then they become a doctor and you know, right? After their 4 years. I would do 1 year of intense cramming. This is legal writing. This is the basic contracts. This is this and this and this. The second year, you fill it in with like, oh, look, I'm an elective. I'm going to study environmental law. I'm going to go save the world. Then you get people, I'm going to do labor law. I'm going to do whatever, you know? And it's kind of like, okay, I'm going to pick an area, but they've never worked in it, so how would they know, okay? So I would focus, Leslie, on first year, give me all the basics, teach me how to think like a lawyer, teach me how to write like a lawyer, and then go do like a residency. You're going to go do 6 weeks at a firm that does securities law. You're going to go do 6 weeks at a firm that does criminal defense. You're going to go get that exposure because most people don't know what kind of law they want to practice. And unless you get some sort of internship in school, how do you know? Maybe a summer clerkship. Okay, you get 6 weeks, you float around, a law firm. Maybe they let you, do a little research or something along those lines. How do you know what you want to study? Like most things in life, you don't know what you want until you figure out what you don't want, which is, I certainly don't want to practice that kind of law. God, that was boring. Put a hot fork in my eye, right? That kind of stuff. So hopefully that answers your question, Leslie. But yeah, law school, 3 years, too long. Law school needs to be think like a lawyer, write like a lawyer, get all that emotion out of you, okay? Teach you how to run a business like a lawyer. I mean, it's the kind of thing where, and I deal with, I have attorneys that work for me, and they come in like, oh man, this case, blah blah blah, it's great, blah blah, and you're like, okay, how much did you charge? Like, we're not going to lose money on that case. Like, if you want to work for free, guess what? I'm going to have to, take it out of your salary because we can't do that. So I would get back to basics. Learn how to run a firm. They don't teach you anything about the business of a law firm in law school. Teach me how to think, write like a lawyer, and all the other stuff you can learn when you get out there once you figure out how it is. So yeah. Jody, $5 super chat. Thank you very, very much.
There's another super chat, Michael.
Oh, it hasn't shown up yet. Here, let me give it a quick refresh. Oh, Michael Palmer. Okay, Michael. CrimeTalk. Scott. Can someone aid and abet a conspiracy as well as be charged as a co-conspirator or principal in the same conspiracy? Aid and abet requires someone else committed the crime, not you. Is this like a law school exam, Michael?
Taking his finals right now.
Listen, a conspiracy to commit an illegal act. A conspiracy is an agreement between two or more people to commit an illegal act. All of the co-conspirators do not necessarily have to know one another. It's not like they all three sit around. But if I'm going to conspire to do bad act A, and you know about it, and you're like, going to help me? Yeah, I'm in. And then you go off and you have all your other people help you complete the conspiracy, they're all in the conspiracy, whether they do it or not. I don't think that I've ever seen somebody charged as aiding and abetting a conspiracy. You're kind of either in it or you're out of it. And the only way you can get out of a conspiracy once you're in it is the conspiracy come to an end, i.e. the completion of the goal, or you completely renounce your involvement in it. But, which I always think is funny because you can form a conspiracy with a wink and a nod, a nudge, not even saying anything. But to get out of the conspiracy, you must renounce to the whole world, or at least the co-conspirators, that you are out of it. So hopefully that answers your question, Michael. I've never seen aiding and abetting of a conspiracy. Usually if you're aware of a conspiracy and you're helping them, you're a co-conspirator. And I'm trying to think, because aiding and abetting, it's a separate offense, but then you have complicit. People oftentimes get complicity and conspiracy confused. Conspiracy is a crime. Complicity is a theory of prosecution where if you aid, encourage, assist, or abet somebody, you could be charged as a principal for your involvement. But it's a theory of prosecution, okay? And usually the DAs figure that out by the time they get to jury instructions. So let's see here. Lynette, I think they could be potentially disbarred. I think that's referring to the Supreme Court people, whoever leaked it. Debbie, Canadian here. From what I know of history, it wasn't in your Constitution because women had no rights back then. And so, of course, the men wouldn't think about it. Well, Debbie, I cannot necessarily disagree with you on that. I think you are correct. Take a look, right? We didn't even have the right of women to vote until, was it 1910 or something like that? 1919. Okay. So I get it, but there's a way to change the Constitution, and they did. They added the women's right, the right to vote. And it wasn't like men were saying, hey, it would be nice if we let the women vote. I'm sure there were some, but most of them, right, the women's suffrage movement brought all that to being, and they're the ones that basically told their husbands, you're going to give us the right to vote. And they said, well, it's not in the Constitution. So since it's not specifically there, it didn't specifically exist, so the only way to do it was to amend the Constitution. Kind of makes sense. And there's a way to amend it. Everybody wants to be like, well, I don't like this part of the Constitution, or I want this. And they just think they can run off to the courts, and the courts will give it to them. The safest way to do it is to is to amend the Constitution, change it. And that's what they did with the women's right to vote. So it's very clear, right? It's the 19th Amendment, right? The right of citizens of the United States to vote shall, which is mandatory, not may, not should, but shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation. Boom. Cleared it all up, right? Because remember, when you go back to the original part of the Constitution, they decided how they were who got the right to vote, and you had to be a landowner, and then yada yada yada, all that good stuff. They said, well, it doesn't say woman. Not my words. That's in the Constitution, right? So they had to fix it, and fix it they did. Let's see here. Take a look at some of these other things. Is this another super chat or is this Michael? Okay, same one. Hopefully I answered Michael's question. Do I hopefully get to pass the law school exam here? Athena, they don't legislate over men's bodies. I don't know what to say. Why should men who have incestuous relations with their daughters be a case that his daughter, a victim, would have to be forced to have a child? Disgusting. Well, Mel, I don't know. My thinking is that most of those cases when it involves or some sort of sexual assault, incest, something of that nature, that there would be usually an exception for that. And, like I said, that's the way it is in most states when there's exceptions. But before they couldn't do that. Catherine Liu writes, would a constitutional amendment to allow abortions pass in enough states? I don't know. You need, how are we going to do this here? Let's see here. Let me just take a look. Because I like getting the language correct. Anyway, they could, if you get enough people to pass it, right? States can do it. Congress can introduce it, send it off to the states. There you go. Clumsy clairvoyance. The fact that it was leaked was a little disturbing. That has got to absolutely rock the Supreme Court. That just does not happen. And obviously, I've never served as a clerk at the United States Supreme Court. Nor would I ever be a Supreme Court justice. But they've kind of pride themselves on secrecy. And even when people don't like the decisions that come down, even the justices don't like it or criticize it. And so for somebody, who knows, was it a civilian employee, a law clerk, even a justice? Who knows? And what was their goal? To get people all fired up, I guess? It could be working. We'll see. I don't know. Athena said this was intentional. Claire, what does the Supreme Court plan to do with all these unwanted children? I don't know, but I bet they're not going to raise them. That's for sure. Mel, funny how Scott gives his political opinion on other topics, but won't on this issue. Well, Mel, every time I put my big toe in anything political issue, guess what? I get yelled at, and people start yelling at me, and so the best way to do it is just talk about what the law is, where the law is going, and leave it at that. Girl Friday. So does that mean it will be written more clearly and precisely? No. I don't know. The laws depends on how the laws are drafted in the in the states. And then it'll be a state issue, because before it's kind of been a federal issue since 73. So, Michael, would you take like a Chris Watts as a client, someone you know is bad? Everybody's entitled to representation. What responsibility placed on the men that helped create a pregnancy? They can just walk away with zero consequences. Well, hopefully, if somebody's going to help create a child, hopefully the guy would also stick around, or, there's a thing called paternity tests, and they can be financially responsible for that child until they turn 18 years of age. Somebody that creates a child and walks away from it is not exactly a good person. Now, would they be? Okay, we've got Leslie's thing there. The other issue is obviously, let's go somewhere where I can certainly get in trouble. Johnny Depp. The Johnny Depp case, the Johnny Depp prosecution or plaintiff rested their case. The defense for Miss Heard made a motion for a directed verdict, saying, Judge, there's no way that you could find, a reasonable jury could conclude in any way for Mr. Depp, and the court denied that. But said it will take it under consideration when they hear the rest of the evidence, which is normal, very routine. The judge is going to say, I'm not going to substitute my judgment as the extra juror, so to speak. So that's the way that is. Scott, what do you think of 17-year prison guard that sold her home, retired Friday, picked up her convict, and disappeared with him? You just can't make this stuff up. Apparently she sold her house, told people she was retiring. Friday was her last day, the day that she said that she was going to take this guy to court for an evaluation and then a doctor's appointment, and never came back. She abandoned the police car, I think roughly 8 minutes from the police station, apparently departed some other way, and has not been seen or heard from again. Didn't tell her family, didn't tell anybody, no clue where she is. The guy is 6'7" tall or something, 6'7", 6'9". 6'9". He's not going to be a hard one to spot, walking down the street. But it just shows you, man. I mean, somebody meets somebody, they rock their world, they're like, I'm going to give it all up. I just don't know if it's worth going to jail for. Let's see here. All right. Melania, I don't want to know Scott's political views. Just want him to talk about the law and how he thinks the issues will be addressed. If I were having a martini with him, then yeah. What is your view, dude? Yeah, there you go. Let's see here. Just look at the things. Okay. All right. I think we're going to end a little early tonight. And then we're going to do our Patreon, and we'll go from there. All right. We'll see all our Patreons here in just a few minutes, and have a wonderful night. We'll see you next on Crime Talk. Thanks for watching.